In this final session, I'm going to be talking about pensions and 2P. So let's start with auto-enrolment. According to the TUC, that is a pensions new deal. According to Steve Webb, the pensions minister responsible for bringing in auto-enrolment, it's a truly radical social change. And according to The Guardian, it's simply the biggest shake-up in pensions for 100 years. But what actually is it? Well, auto-enrolment is a new law under which all employers must pay minimum pension contributions to workers unless they either opt out or are already members of a qualifying scheme. When's it happening? Well, for the very biggest UK companies, it's here already. Their staging dates, the date on which they had to start auto-enrolling employees, were the 1st of October this year. And as you can see from the slide, there's a rolling programme of staging dates between now and April 2017. If you are an employer, you will be written to by the pensions regulator 12 months and again 3 months between your particular staging date. You then have 1 month to enrol your eligible workers and 4 months to register online with the pensions regulator. Who's eligible to be auto-enrolled? Well, all permanent and temporary employees, including contract and agency workers. And in certain circumstances, also self-employed individuals, consultants and casual workers. All of these, of course, subject to certain age and earning thresholds, which we'll have a look at now. In this chart, you can see the 3 categories of workers under the new regulations. If I can focus you first on the red section, entitled Eligible Job Holders, these are employees who earn more than £8,105 a year and who are aged between 22 and whatever the state pension age is at the time. These are the eligible job holders. These are the employees who must be enrolled automatically into the new pensions and for whom the employer must make the minimum contribution. For those employees who are either too old or too young to fall into that group, or who earn a little bit less, between £5,564 and the threshold £8,105 per year, these employees are known as non-eligible job holders. They're entitled to participate in the scheme in exactly the same way, but they have to opt in. There's no duty on the employer to auto-enrol them. You'll also see there's a third category of employee called entitled worker, and these are employees earning less than £5,564. Again, these employees are entitled to opt into the scheme and enjoy its benefits, but if they do so, the employer doesn't have to contribute. What are these minimum contributions? Well, these will be brought in stages from 2017, and by the final date of 1st of October 2018, the idea is that the total contribution between employer and employee must be 8%, of which the employer must contribute at least 3%. Do bear in mind these are minimum contributions, and employers are of course free to have higher contributions from both themselves and their employees if they so wish. At the moment, the earnings that qualify for those contributions are those above a minimum level of £5,564 up to a maximum figure of £42,475. Now, of course, between now and 2018, when the full contributions become payable, these bands are likely to adjust upwards. So watch this space. The schemes that qualify for auto-enrolment pretty much include anything. Defined benefit, defined contribution, hybrids between the two, or even schemes run from outside the UK altogether. All that matters is that they satisfy the pensions regulator. Because this is so new, so revolutionary, and that now every single employer in the UK, including those businesses that are employing just a single person, will come under this new regime. To assist with that, the government have set up a whole new pensions provider. It's called Nest, stands for National Employment Savings Trust, and it's intended to be a pension scheme that's available to everyone, low charges. However, there is a cap on the contributions that are able to be paid into it, and there are also limits on the ability of employees to transfer money in and out. But it's there, a low-cost option if you need it. I'm now going to move on and talk about 2P, that is, the Transfer of Undertakings regulations, the most recent version of which dates from 2006. We better just remind ourselves first of all what 2P is. 2P applies essentially to two situations, the first of which is when you take over a business. And the test that applies here for 2P is whether there is a transfer of an economic entity which retains its identity. And the definition of an economic identity is an organised grouping of resources with the objective of pursuing an economic activity. So far, so good. However, in 2006, a second category of situation was introduced to which 2P also applies, and that's a service provision change. This means outsourcing, changing your outsourced contractors, or taking services that were outsourced back in-house. And here the test is different. This time there needs to be an organised grouping of employees in Great Britain which immediately before the transfer had as its principal purpose the carrying on of relevant activities on behalf of a client. Now, there's been a lot of concern in business circles that these new regulations in 2006 significantly increased the bureaucratic burden on small businesses. And the government was sufficiently concerned to put out a call for evidence to interested parties, which they did at the back end of 2011. They've had all those responses back, and in September of this year, the government published its response to those replies. And a number of issues were highlighted in that response. The first of those is the difficulty of harmonising terms and conditions of employees when you try to bring businesses together that you've acquired. Essentially, it's not possible to do that without putting yourself, firstly, at the risk of constructive unfair dismissal claims, and secondly, even giving yourself the certainty that you can impose those changes. Because under 2P, if you change someone's terms and conditions for a reason connected with 2P, the change is void. The second problem, which I alluded to earlier, is that simply applying 2P to service provision changes has had a disproportionate impact on small businesses who very often want to use the outsourced services of other companies because simply they can't afford to carry out key functions in-house. And the third key issue highlighted in the government's report is that however you acquire a business or take on an outsourcing contract, if you try to then provide those services from a completely new location, you're at quite serious risk of having automatically dismissed any employee who chooses not to work from that new location, which is a pretty major problem right now. So what's happening next? Well, the government tell us there's going to be a period of policy design. They're going to have a look at the issues raised and decide whether there's anything they should do about it. In doing that, they will engage with key stakeholders, and there'll be a consultation with a view to amending the 2P regulations. It's fair to say that in their response, the government have acknowledged the difficulty of doing this because, of course, 2P comes directly from a European Union directive. However, they say they're going to do it, so let's watch the space. Well, that brings us to the end of today's presentation. If you have any questions arising out of anything that you've heard, please don't hesitate to get in touch with us via our website.